Assalamualaikum dan salam sejahtera. We're gonna present about the Torren legal system in Malaysia and how different it is from other countries. Before we start the presentation, let me introduce my group members. AMNI AMIRAH, Nurul Azizie, Nurul AQILAH, HUSNA HANAN, and the last one is ATHIRAH.
The Torren system. It was promoted by Robert Richard Torren, who is appointed Registrar General of Deeds for South Australia. It then was created by Maxwell after he returning from Australia to investigate land tenure under British colonial control in Malaya. The Torren system was deemed to be appropriate for Malaysia's land tenure system. The term Torren title refers to a single central land registration system. This record includes every piece of land as well as the owner's name. In order to transfer the land, the ownership must be transferred through purchase, sale, death, or etc. Under this system, each parcel of land gets its own certificate of title. The certificate includes a volume and folio number, ownership information, easements or rights, and any encumbrances such as mortgages, leases, and other interests in the land. Compared to Australia, a court or registration bureau oversees the system. This means that the landowner petitions the registrar to have his or her property registered. Then the registrar issues a certificate of the title if the owner has a legitimate title. This certificate is typically definitive as to the individual's ownership rights in the property, and it cannot be challenged or reversed in court. In general, the Torren system is based on two main principles. Mirror principle. In this principle, the register contains all important details concerning a person's ownership of his or her land. The ownership is clear as well as safe, obvious, and straightforward. In other words, the register of titles record of what is on the land reflects this concept. This method assists prospective buyers, leases, and charges in collecting essential information. For example, if someone desires to sell an estate, the new title must be equivalent to the existing one. The curtain principle. In this case, there is no need to look any further than the title certificate, which contains all important information. The potential buyer is only required to pay attention to the register during any transaction between the registered owner and the prospective purchase. This means that the buyer does not need to conduct any more research since he or she can rely on the information included in the register. There are several objectives of introducing the Torren system, which is to overcome the defects of the deeds system, to provide simplicity and certitude, to deter the legal technicalities in land dealings, and to provide security of title and facility of transfer.
I will present about review of the case Dr. T. Tiao Siu and Os versus Pendaftar Geran-Geran Tanah Negeri Selangor. In this case, land has been alienated to the first applicant, the title being endorsed with the following endorsement of restriction in interest, which is the land hereby leased shall not be transferred or leased for a period of 15 years without the consent of the ruler in councils. So the story of this case is actually applicant 1 has submit a land transfer form for the purpose of transferring the land to the applicant 2 and 3. After that, applicant 2 and 3 have complete form for the purpose of mortgaging the land to the finance company. Both of the instruments were submitted to the respondent for registration purpose. However, the respondent refused to register the instrument on the ground that the restriction or interest for the title was still in force, which is until 8 November 1982, taking into account the effective date of the restriction of interest on 9 November 1967, which is from the date the title was registered. Meanwhile, applicant 1 understood that the effective date of the restriction of interest was 18 August 1964, which is from the date the land was first allocated, and ended on the 17 August 1979, regardless of the date the title was registered. So, from the story, the hell of this case is actually the restriction in interest commence from the date of registration of the registered document of title, that is 9 November 1967, and the respondent was therefore correct in rejecting the documents present for registration. So, this case have proved the importance and priority of register, which is title document, and the concept of registration under the Torren system. The information in the register, which is title document, has shown and confirmed that the title was registered on 9 November 1979. Thus, the grantor of ownership of this land and its title came into effect on that date, which is according to section 78 article 3 of the National Land Code. Next, while under the Torren system, the registration action performed by the registrar is very important because an instrument, memorial, entry or notes in the register, which is the title document, must be signed or endorsed by the registrar so that it become valid and effective as specified under the section 304 National Land Code. So, in this case, the determination of the date the title was registered has been the main matter or question, and a misinterpretation of it has resulted in the instrument of transfer and charge submit by the applicant not being able to be registered, as it is still subject to restriction of interest still in force.
Okay, now for the next case is a case of Tebi versus K Marutamutu. The appellant, which is Tebi, is the owner of the land who has been registered under title HST 1089 PT number 7 Daerah Seremban on 24th January 1968. As the owner of the land, the appellant can't stay and use the land because it has been occupied and pursued by the respondent. So, before the land is alienated to the appellant, it has been approved by the temporary occupational license to the respondent, which is effective until the end of 1967. The respondent claimed that the appellant had illegally acquired and registered as the owner of the land because when the appellant makes payment as specified in Form of 5A National Land Code, the approval of the ownership of the land has been lapsed and void. Then the case has been referred to High Court, and Judge Azizie had ruled that the registration of the title was invalid and void, as the approval of its ownership had expired and was no longer in force. Following the decision of the High Court, the appellant has appealed to the Federal Court for the land to be vacated by the respondent to enable her to occupy and work the land. The appellant argued that she is a lawful registered proprietor and her title has already been registered and issued to her. As such, the respondent has occupied and cultivated the land illegally, which is categorized as trespasser. The Federal Court then allowed the appeal and decided as following. First, the fact that the appellant was registered as proprietress necessarily raised the inference that the state authority on payment of the premium had given fresh approval for the alienation of the land to her. Second, the fact that the registered document of title was in the name of the appellant was conclusive evidence that the title to the land was vested in the appellant. And the third, under the Torren system, the register is everything, and it would be wrong to allow an investigation as to the right of the person to appear upon the register when he holds the certificate of title. So, through this case, the Federal Court has stated that register is everything. Thus, once a title has been registered, then the matter of ownership of the land has become final and effective. Any information and facts contained in such title are valid and binding. Once the title registered in the name of the landowner has been recorded therein and the title has been issued to the appellant, then in such a situation it is inappropriate to allow any party to investigate or dispute the rights of the party whose name has been registered in the title.
The case that I will talk about is the case of Muhammad Buyong. versus Pemungut Hasil Tanah Gombak 1982 with the principle of register is everything. Based on this case, there is a circular that has issued, which is the registrar has the authority to make corrections only in circumstances where the mistakes was committed by him or an officer or staff of the office registration, and the registrar has no power to make corrections in circumstances on which the error was made by another party. The court has also ruled that the error was minor, which requires correction need not to be referred to the High Court in advance formally because of the registrar himself, either the registrar of the titles or the land administrator, does have the power to rectify it below section 380 of the National Land Code. Through this case, it is very important for registrar to register any instrument by making memorial on the registered document of title under his hand and seal. In this case, an entry of transfer was not signed. It constituted a bad entry, and since it was not signed by the collector, there was no registration affected. The appellant contended that he is lawfully entitled to the 12/19 shares of the said land by reason of the sale and purchase, and in fact, according to him, he was the duly registered propriety. He also contended that the collector had no power or authority or jurisdiction to cancel or delete the transfer which he considered to have been registered on August 14, 1979. Therefore, the appellant seeks to quash the decision of the collector and also for a declaration that the subsequent registration of the transfer of the undivided share is bad and should be set aside. There is a few issues that was concerned. The first one is whether the appellant is entitled to the protection of section 340 of the National Land Code. The essence of the section 340 of the code is that registration is prerequisite of indivisibility. However, the entry made on August 14, 1979 was a bare entry and it was never signed by the collector. It is provided under section 304 article 2 that the registrar shall register any instrument by making a memorial under his hand and seal. Therefore, if any such memorial is made without the registering authority signing and sealing it, there will be no registration. Section 217, Article 2 of the Code also mentioned that the undivided share of any land transferred shall pass and vest in the transferee only upon registration of the transfer. Thus, the appellant is not entitled to the protection under Section 340 of the Code because there was no registration. The second issue is whether the collector was correct in law in cancelling or deleting the entry made in the register. Power of the collector or registrar to correct errors is only mentioned in section 380. However, it does not speak of cancellation or deletion. Only section 382 touch that relating to endorsement. The question arises on what sort of corrections can be authorized by section 380. In Island and Peninsula Development Berhad and Anna versus Legal Advice Kedah, the High Court interpreted section 380, article 1A, confined to error or omissions made by registrar and not the parties concerned. David Wong, on the other hand, stated that in his book that it may refer to administrative mistake that it shall be wide enough to include other circumstances. Section 380, Article 1B, was elaborated by Hashim Yubji to be wide enough to include any entry that was wrongly recorded by the registry. The court was asked to adopt a common sense attitude in the present case. It is held that the entry made on August 14 never acquired to sanctity of a memorial of registration pursuant to section 304, article 4 shall be conclusive. Thus, the cancellation can be properly executed. So, the conclusion, it was held that although the instrument of transfer had been presented and recorded in presentation book, it is not being registered, thus appellant cannot claim indivisibility under section 340 of National Land Code. The matter then is to be correlated with second issue where the cancellation shall be valid as the entry never acquired the sanctity of memorial under section 304 article 4 as conclusive evidence of registration. It was also held in the last issue that although technically the act of the collector in registering the instrument to second, third and fourth respondents will be in breach of section 300. The words shall not in section 300 article 1A are on facts of the case is merely directory and not mandatory, and the apparent failure of the collector to comply with the section did not invalidate the registration. The appeal was dismissed and the court is in favour of respondents.
The next case is Gibbs versus Messer. The Privy Council said in this case that the principal objective of the Torren system is to save those who deal with landowners the difficulty and expense of having to study the background of the property in question to satisfy them as to its validity. When we look at this case, a woman owned a land and transferred the title certificate and power of attorney to her solicitor in order to give her husband power. The solicitor forged a transfer to a fictional person and had the woman's name erased from the register. The money then was used to arrange a mortgage by the solicitor. The mortgagee was unable to register the mortgage because proof related to the fictional person was required, and more paperwork were forged by the solicitor and it was registered. The woman then filed a lawsuit against everyone and demanded that the title be restored to her. As a result of the scam, the woman's title to the property was returned to her free of the mortgage. The purpose of the legislation is to save people the trouble of investigating the title and to provide indivisibility to bona fide purchasers who have registered. This case is crucial since it proves the system's integrity. According to the facts of this case, it was invalid since the mortgagee should have confirmed the register's accuracy.
I will be presenting about the review of Torren system in Philippines. The Philippines subscribes to the Torren system of registration as it is believed to be the most convenient for proving real estate ownership and minimizing ownership disputes. Under the Torren system, certificates of title are used to real estate owners after a thorough evaluation of the deed of conveyance, applicants' qualifications to own real estate, compliance with Philippines law, rules and regulations, and payments of applicable and sufficient taxes. Registration under the Torren system creates a general guarantee that the certificates of title are conclusive in favor of the owner named in the registration certificate. This case is between Metropolitan Manila Development Authority versus concerned resident of Manila Bay. This case was decided on 18 December 2008 by Philippine Supreme Court. The case involved a complaint filed by concerned citizens fearful of the pollution affecting the ecology of the bay and the health of inhabitants of the area surrounding the bay. The complaint took to task certain government agencies for their failure to preserve the cleanliness of Manila Bay. As a consequence of the case, all establishments and projects in Manila Bay must comply with the policies currently being implemented and those that may be imposed in the future by government agencies in relation to the restoration, rehabilitation, and preservation of the water quality of Manila Bay. Comparing Torren system implemented in Malaysia and Philippines. The Philippines uses the Torren system of land registration. Under this system, a Torren title is conclusive against third parties, including the government. A holder of a Torren title in good faith is guaranteed that his or her title is indefeasible, unassailable, and imprescriptible. Malaysia has adopted three versions of the Torren system. Firstly, For Peninsular Malaysia, this is enacted in the National Land Code Act 56 of 1965. Secondly, for the state of Sarawak, this is enacted in the Sarawak Land Code Chapter 81 of 1958. For the state of Sabah, this is enacted in the Land Ordinance, Sabah Chapter 68. Unlike the National Land Code and Sarawak Land Code, the Land Ordinance Sabah Chapter 68 does not provide any indivisibility of title.
So, as in conclusion, it is finally possible to realize the principle that under the Torren system, register is everything needs to be trusted and believed its completeness and validity, unless there are certain factors that can refute it. The principle of register is everything places the dignity of the register as the final and conclusive main document. By its nature, the register contains and displays a variety of important facts and information about it clearly and transparently, in accordance with the mirror principle applied under the Torren system. Meanwhile, through the certain principle, any party who wants to deal with the title and land only needs to focus on the information in the register, and there is no need to doubt and question the validity of the information displayed through the register. However, in certain circumstances, there are exceptions or deviations from the principle of register is everything. So, on the whole thing, register is everything is a principle practice under the Torren system, especially for this country, which is enforced through National Land Code. So I think that's all from me and my group. Thank you.